We're here today in the state of Ohio versus Joseph Hennessy, case number 26-CR-425. The defendant is present with counsel John Fatica. We're here today for an information hearing. It's the state's understanding the defendant is going to waive his right to have this case presented to the grand jury and enter a guilty plea to the one-count information, that one count being attempted domestic violence. If that plea is forthcoming and accepted by the court, the state would then ask for a pre-sentence report and victim impact statement, and there is no agreement as to sentencing. Thank you.
Thank you. Mr. Fatica, does that sound correct?
Yes, Your Honor.
Thank you. And Mr. Hennessy, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here at this time?
Yes, Your Honor, I heard everything clear.
They indicated to the court they believe it's your desire to waive your right to have this case presented to a grand jury, and I'm going to explain in a moment in more detail what that means. Then you're going to plead guilty to the charge and the information, which I will also review with you to make sure you understand that. We would then, you'd then enter plead guilty. We would defer sentencing. I'd order some evaluations get completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and most importantly, what you want to do here this morning?
That's exactly what I want to do, sir, and yes, it's my understanding 100%.
All right, well then, before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand the rights you're giving up, the penalties you face, what you're pleading guilty to. So I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you want anything repeated or clarified, if you want a moment to talk with your lawyer so you can ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything that we're doing, all right?
Okay.
All right.
Your Honor, thank you.
Very good. Let's get started then. How old are you, sir?
63.
Are you able to read and write the English language?
Very well.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
I am, sir.
Now, before coming into court here this morning, have you any drugs or alcohol of any kind?
No, not at all, Your Honor.
What about in the last 48 hours?
Not at all, Your
Not
Honor.
even prescribed medication?
Nothing, Your Honor. Nothing, sir, at all.
Now, did you receive a copy of the information that was filed? It's the document that sets forth the specific charge that you're accused of committing, what you're pleading guilty to?
I did receive a copy, and me and Mr. Fatica did go over it, Your Honor, in the room back there.
Okay, well, I'm going to review that with you right now. If you have any questions, you can ask. But what's alleged here and what you'll be admitting to is on or about March 22nd, 2026 in Paynesville Township, Lake County, Ohio, that you did purposely or knowingly and with sufficient culpability for the commission of the offense of domestic violence, engage in conduct that, if successful, would constitute or result in the offense of domestic violence. Domestic violence is defined as knowingly causing or attempting to cause physical harm to a family or household member, that being an individual with the initials RS in this particular case. So that's what domestic violence is. Attempt is that you engaged in conduct that, if successful, would have resulted in the commission of that offense. And the significance of that is it reduces a level. In this case, it's alleged that you have a prior conviction for domestic violence that was on March 5th, 2012 in the Paynesville Municipal Court. As a result, domestic violence would normally be a felony of the 4th degree, but because it's an attempt, it reduces it to a felony of the 5th degree. So do you understand what you're charged with in this particular matter?
I do, Your Honor.
Any questions for me about it?
I do not have any questions, Your Honor.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you are giving up. And you first of all have the right to have this case presented to a grand jury. So the document I just read to you is called an information. And an information is a criminal charge brought by the prosecutor without the case having previously been reviewed or considered by a grand jury. Now what a grand jury is, it's made up of a group. What was that noise? What was that outside there?
Yeah.
What a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everyone here in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well, but you can give up that right if you desire. Go forward on the charge brought by the prosecutor in the information, and your attorney has indicated he believes that's what you want to do. Is that correct?
That is what I want to do, sir, yes.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing, and I have in front of me a one-page document called a waiver of indictment, which explains what I've just explained to you about the grand jury, and that you want to give that up. Before I can go any further, I need to be sure you understand what this document says and that you sign it here in open court. Now, my understanding is before I walked down here, you had a chance to go over that with your lawyer. Is that correct?
Yes, Your Honor, it is.
Mr. Fatika, is that accurate? Did you review this with Mr. Hennessy, read it over with him, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you?
He did.
Is that correct, Mr. Hennessy?
Yes, Your Honor, it's
And
correct.
any questions for me about what it says?
None at all, Your Honor.
It also appears that you signed the document. Did you sign it?
I did.
And you witnessed that, Mr. Fatika?
Yes, Your Honor.
And you too, Ms. Bell?
I did, Your Honor.
Very well, then I'll make this document part of the record. At this point, Mr. Hennessy, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And you, first of all, have a right to a trial. And a trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. That means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of the charge. You understand that?
I do, Your Honor.
Do you understand by pleading guilty or giving up your right to have a trial in this case? Do you understand that by pleading guilty or giving up your right to have a trial?
Oh, yes, Your Honor, yes, yes.
Now, if we had a trial, the prosecutor here would represent the state of Ohio, and she would have what we refer to as the burden of proof. By having the burden of proof, what that means is that it is her job, or she bears the responsibility, she bears the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of the charge, and that presumption of innocence sticks with you and remains with you until the state, if at all, is able to present enough evidence that would overcome the presumption and prove you guilty. Do you understand that?
Yes, Your Honor, I do.
Now, when I speak of the burden of proof, since it's a criminal case that we're dealing with here, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty. Do you understand that?
I do, Your Honor.
Do you understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
I do understand that, Your Honor.
Now, in order to do that, or at least try to do that if we had a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. So he can ask him anything he wanted to, but within certain rules. Do you understand that?
Yes, I do, Your Honor.
Do you understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
I understand, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
I do, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court and answer your questions and testify on your behalf if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor, I understand that.
Do you realize you're giving up that right?
Yes, sir.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to. Excuse me. But you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir, I do understand that.
So what that actually means is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial. If you didn't want to, I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer came and you could testify if you didn't want to. Do you understand that?
Yes, Your Honor, I do.
Further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor, I understand that.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
If that's directed at me, no, you've
It's
made
directed to you.
everything very clear, Your Honor, and I have no questions.
You still want to plead guilty?
Yes, I do, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor, it's a wrap. This ends the whole proceedings.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
I do, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 5th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number within that range of 6 to 12. Do you understand that?
I do, Your Honor.
Now, are you currently on probation or parole, PRC, to any other courts or agencies, any type of supervision?
No, sir, no, not at all, Your Honor.
Do you have any other charges pending against you anywhere?
Nothing, Your Honor.
If a prison sentence is imposed at the time of sentencing or at any point, upon your release from prison, you could be placed on what we call post-release control. It's sometimes called parole or PRC. It's a period of supervision you'll be on after you've completed the prison sentence. In this particular case, it's not mandatory, but it's up to the parole authority to decide that. It could be up to 2 years. Do you understand that?
Mr. Fatika explained that to me in detail. Yes, sir, I understand it.
Okay. And if you were put on post-release control at any point and ever violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
I do understand that, Your Honor.
Now, aside from the possible prison sentence, there are penalties and sanctions that can be imposed. You could be fined up to $2,500. You could be ordered to pay court costs. You can also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
I do, Your Honor.
You could also be ordered to pay restitution if it was applicable in this case for any economic loss that any victim may have suffered as a result of the conduct. Do you understand that?
I do, Your Honor.
Now, a few moments ago, I explained the possible prison sentence. I did use the word possible. Prison is not mandatory with this charge. You are eligible for probation or what we formally call community control sanctions. Do you understand that?
I do, Your Honor.
Do you understand that just because you're eligible doesn't mean you automatically be put on probation? It means I'll consider that if that's what you're requesting. I'm going to look at all the information that gets presented. Then I'll make the decision I ultimately think is the right thing to do. You understand that?
I do, Your Honor.
Now, if you were put on probation, it could be for up to 5 years of supervision, and as a judge, I would have the discretion to order a wide variety of rules and conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
I do, Your Honor.
Further, if you're put on probation and you ever violated any of the rules or conditions of your probation, we would have a hearing here in court to see if you're what's called a probation violator. And if it was determined that you were after a hearing, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, including local jail time, or I could terminate or end your probation at that point and send you to prison then. If I did it at that point, it could be 6 to 12 months in prison, which could also be consecutive to any other prison sentence you may be serving for something else, or that you're being sentenced to at that time for something else. Do you understand that?
I understand, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right on that day to say anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
I do, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just that. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
I do, Your Honor.
All right. Well, do you have any questions for me about the potential penalties you face and what can happen at sentencing?
That's all pretty clear, Your Honor.
Do you still want to plead guilty at this time?
I do, sir, yes.
Have you had enough time to talk about this case with your lawyer and have him go over everything with you and answer your questions?
I believe I did, yes, sir, Your Honor.
Are you satisfied with his advice and
I
counsel?
am 100% satisfied, Your Honor.
Has he or anyone actually made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
I was promised that ultimately it's in your hands.
That's the only promise you were made?
That's the only
All
promise
right.
I was made.
I've never heard that before, but I guess that's fair. But you were never promised what was going to happen.
No, sir, not at all.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering your guilty plea freely and voluntarily?
Of my own free will, Your Honor, 100% yes.
All right, then you have any questions for me at this time, Mr. Hennessy, regarding anything we've talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions?
No, it's all here.
All right, do you need any more time to talk to Mr. Fatika or ask him any questions?
About this?
About anything having to do with this before we enter your actual plea?
No. Yeah,
All right.
I'm good.
All right, then what's going to happen now is the prosecutor here will explain for me what she believes the facts would show if we had a trial. I need you to listen to what she says because then I'll have some questions for you about that. So, Ms. Bell?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on March 22nd, 2026, in Paynesville Township, Lake County, Ohio, Joseph Hennessy did knowingly engage in conduct that, if successful, would have constituted domestic violence. Specifically, the defendant struck the victim, Robin Sigeti, in the face multiple times. The defendant and the victim have a child in common. The defendant previously was convicted or pleaded guilty to domestic violence in the Paynesville Municipal Court case number 12 CRA 227, and that's dated March 5th, 2012. Thank you.
Thank you. So, Mr. Hennessy, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor, I heard everything she said.
And what, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
It is what it is. That's what it is. It's true. It's true, Your Honor. I'm sorry, I complicate things, sir.
So you did what she said?
Yeah, it happened.
Very well, then regarding count 1, charging with attempted domestic violence, a felony of the 5th degree, what is your plea at this time?
My plea is guilty to attempted domestic violence of the 5th degree.
Okay. I have in front of me now another document. This is 4 pages called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. My understanding is, again, before I came out here, you had a chance to go over this document as well. Is that correct?
I'm sure we did. Your Honor, yes.
That's just...
Yep.
Mr. Fatika, is that accurate? Did you review this with Mr. Hennessy, read it to him, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you?
He did.
Is that correct, Mr. Hennessy?
Yes, Your Honor.
So you understand the document?
Oh, yeah.
Any
Yeah.
questions for me about it?
Nope.
It also appears you signed it. Did you sign it?
Yes, I did, Your
Third
Honor.
page? Okay. And Mr. Fatika, you witnessed that?
Yes, Your Honor.
And Ms. Bell, you as well?
I did, Your Honor.
Very well, that at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court further finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, attempted domestic violence, felony of 5th degree in violation of 292302 and 2919.25. On the first sentencing, order pre-sentence report investigation, drug and alcohol evaluation, and victim impact statement. Is there anything else for the record at this time, Ms. Bell?
Nothing further, Your Honor. Thank you.
Mr. Fatika.
Your Honor, we'd like to be heard on bond.
Okay.
Mr. Hennessy's bond was revoked in Paynesville Muni Court on March 31st of this year. He tested positive. He denies using that bond, believes it was a residual effect from prior use before being on bond.
What did he test positive for?
Meth.
Go ahead.
He's worked in restaurants for years. He works at 3 different restaurants now. If released on bond, he would reside at 312 Vine Street, Fairport, Ohio, with his mother, who's in the back of the courtroom. She's in need of his help. We'd ask the court to consider giving him an opportunity to post bond, show you that he could timely appear for his appointments, be cooperative, and stay clean through the PSR process.
This happened on March 22nd. When was he arrested? That day?
That day.
He tested positive March 31st, April 1st? Well, it's not residual effect.
Sir, Your Honor, I was not arrested the day of the incident. I was arrested the following day at my job.
On March 23rd?
Yes,
All right, so the drug screen wasn't until a week later, 8 days later.
yes, and I...
Well, it doesn't last in your system that long with our testing.
Okay,
It doesn't. Marijuana does.
yeah,
Methamphetamine or cocaine or heroin, everything else we test for is gone within 3 days.
I mean, methamphetamine, yes, sir, I'm shutting up.
Bond's going to remain the same.
All rise.
Oh, yeah. Yeah, yeah. That's true. Yeah, 100%. I love you guys. Give me some money over there, Harry. Go to the bank for me, please. Give me $100. Mom, I love you. Thank you. I'll be about a month, and I'll go to month and a half, and I'll come back and be sentenced. And you know, I love you guys. Send me pictures of that boy. And Jamie, you are my kinfolk.
Doing it all today.
Tucker,
Oh, my God.
it's a wrap, John.
That was rained in.
Don't I got a lot of work. Oh, really? That was rained in? Oh, okay. This is a little comical.
Yeah.
Okay, makes you smile. Have a good day. Oh, you're back? Okay.
We are present in case 25 CR 858, State of Ohio versus Elizabeth Ewing. We're here on the state's for a hearing on the state's motion to terminate community control sanctions that was filed. Scheduled for a probable cause hearing. Defendant's in court with her attorney, Mr. John Fatika. Mr. Fatika, what's the defendant's intentions at this time?
Good morning, Your Honor. I've discussed this matter with Ms. Ewing. She'd like to waive her probable cause at final hearing, accept responsibility for her misconduct, and resolve the violation this morning.
Thank you. Ms. Ewing, you've been charged with violating the conditions of your community control sanctions. Specifically, there's 4 alleged rule violations that you committed. I'll go over those with you in a second. We're scheduled for a probable cause hearing today, which is a hearing where the state will be required to present some evidence to suggest you probably committed these violations. Now, the violations you're charged with is first Rule 11, which says which requires you to comply with all special conditions that are set forth by the court. In Condition 3, you were ordered to enter and successfully complete the treatment program at either Oak Ridge or Nevaeh Ridge, and it's alleged that you were unsuccessfully discharged from Oak House on March 24th when you left the facility. Next violation is a Rule 4 violation, which requires you to report the address at which you were actually living. And on March 25th, after you left Oak House, probation department did not have a valid address for you at that time. The next violation is Rule 3, which requires you to report at such times and places as directed by your probation officer, and you failed to report to probation on March 30th and April 3rd, 2026. Lastly is a Rule 8 violation, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician, and it is alleged that when you were apprehended, you tested positive for methamphetamine, amphetamine, marijuana, cocaine, and fentanyl. Now, you have the right to have, as I said, a probable cause hearing and also a final hearing. A final hearing is a hearing where the state would be required to prove the actual merits of what they're alleging. You can have that hearing and it'll be at another date and time to give you time to prepare if that's what you wanted to do. So you could have either or both of those hearings, but you can also waive both hearings and plead guilty. Your attorney has indicated he believes you want to waive the hearings and plead guilty. Is that correct?
Yes, Your Honor.
Well, before I can go any further, I need to make sure you understand the potential consequences you face if you're found to have violated your community control sanctions. If, in fact, that did occur, the court could extend your probation up to 5 years. I could impose more restrictive sanctions against you, including an order that you serve more time in the Lake County Jail. Or I could terminate your probation and send you to prison. If I did that, it could be 6 to 12 months in prison. Do you understand the potential penalties you face if you're found to have violated your community control sanctions?
I do, Your Honor.
Well, having been so advised, then what do you want to do at this time? Do you want to have either of the hearings, or do you want to waive both hearings and plead guilty to the violation?
Your Honor, I'd like to waive both hearings and plead guilty.
Very well. As to the allegation that you violated Rule 11 by not successfully completing the treatment program at Nevaeh Ridge, what is your plea to that?
Guilty.
As to the allegation you violated Rule 4 by not providing the probation department with an address after you left Oak House. I may have said Nevaeh Ridge, the Oak House. So the first one was that you didn't complete Oak House. But you also didn't provide an address once you left there. What is your plea to that?
Guilty, Your Honor.
For the Rule 3 violation for not reporting to your probation officer as you were required to do so, what is your plea to that?
Guilty.
And for violating Rule 8 for testing positive for amphetamine, methamphetamine, cocaine, marijuana, and fentanyl, what is your plea to that?
Guilty.
All right, the court will accept your plea of guilty, find that you did violate. Mr. Fatika, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, in my discussion with Ms. Ewing, she understands that she didn't take advantage of the opportunities given to her by the court at treatment. As a court's heard, she's accepting responsibility here at this initial PV hearing. She has 127 days total and 8 days on this violation. We'd actually consider all those factors in determining a resolution here.
Ms. Ewing, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say?
Your Honor, I would just like to apologize for not doing what I needed to. I ended up getting in an altercation with a girl there, and I ended up walking out, and I should have just went back. Something in me told me go back, and I just didn't listen. I don't know. And then one thing led to another, and obviously we're here today. But I just wanted to apologize for not, staying and taking advantage of the opportunity. And yeah, I'm sorry.
Well, this court has reviewed the original pre-sentence report and investigation. I've considered the factors and circumstances of the underlying offense, the nature of that offense, defendant's performance on probation, the nature of the violations, and what's been said here today. It's all considered by the court in light of the purposes and principles of felony sentencing set forth in 29-2911. As for the factors in 29-2912, I'm going to incorporate the findings I made at the original sentencing hearing regarding those factors with the additional finding today that the defendant has failed to comply with the previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. When we were here last time, you have a lengthy history. You've been on probation. You've violated. I still gave you that chance because you represented. That's different this time. You're serious this time. You're going to take advantage of this. This is what you wanted to do, and you didn't last a couple weeks. So you're clearly not amenable to community control sanctions. And this is the cycle that's going to happen. If you get out and don't get help on your own, you're going to be back here. You're not going to be getting help from court because I'm not going to be able to believe a word you say when you come back. You're telling me you want help. Your actions are going to have to dictate that. So if you get out and you don't get help, you're going to be right back. You're going to be doing the same thing that you're doing now. And you're going to come back before me and you're going to go right back to prison. And that's going to be the cycle from here on out unless you take the affirmative steps to do anything because we're not doing it anymore. Okay. So just so you know that. The court finds prisons consistent with the purposes and principles of sentencing. Then it's not amenable to community control sanctions. Therefore, the court's going to terminate her community control sanctions and impose a prison term of 11 months in prison. She has credit for 127 days she's served. Need to advise you upon your release. You could be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 5.5 months, maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control, and the defendant's ordered to pay all costs. Is there anything else for the record at this time, Mr. Fatika?
No, thank you, Your Honor.
All right. Mr. DePiero.
Thank you, Your Honor. Your Honor, if it please the court, we're before the court this morning in the matter of the State of Ohio versus Everett Mason, case numbers 25 CR 1613. The defendant is present in the courtroom with his attorney, Mr. Tim Deeb. We're before the court for purposes of a change of plea in accordance with an agreement that's been made between the parties, and if it please the court, I'll put the terms of the agreement on the record.
Please.
Pursuant to the agreement, Your Honor, the defendant will withdraw his previously entered pleas of not guilty and will plead guilty to count 1, felony of the first degree aggravated robbery. He will also plead guilty to the attached firearm specification. That's the 54-month specification under 2941.145, and also to the RVO, repeat violent offender specification under 2941.149 attached to count 1. The defendant will also plead guilty to count 9. It's a felony of the third degree having weapons while under disability count, and will plead guilty to the attached 18-month firearm specification on count 9 under 2941.141. After findings of guilt and at the time of sentencing, the state will move to dismiss all of the remaining charges and specifications on the indictment. As to sentencing, the state will not recommend the minimum prison term. These are mandatory prison offenses, Judge, on these count 1, and the specifications. But the state can recommend any available prison term. The defendant can ask for the minimum. He can ask for anything that he wants that's available sentence-wise. Thank you.
Thank you. Mr. D, does that sound accurate?
Your Honor, the only thing that is different than what Mr. DePiero said was I informed my client that I thought the fine on the aggravated robbery was mandatory. It is not. But other than that, it is absolutely correct.
No mandatory fine in this case.
That's right.
I thought it was, and I had told him that, and he was still willing to plead, Your Honor, but just for that clarification, because I did misinform him. But
Okay.
we clarified that this morning.
Okay. Mr. Mason, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty to a couple counts here and specifications and plead guilty, and I'll go over those with you here in a moment. And the other counts would all get dismissed. We would then defer sentencing to get some evaluations and statements prepared, come back on a future day for sentencing, where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever lawful sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and most importantly, what you want to do here today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you are charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to speak with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Well, let's get started then. How old are you, sir?
32.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
Yes.
What have you had in regards to prescribed medication?
I don't know how to pronounce it.
What's it for?
My schizophrenia.
Okay. That's the Risperdal? Risperdal? You're not sure. Does that sound right?
It
I'll just put
it begin with an
I'll
A.
just put psychiatric medication.
It's a long word.
Have you been taking it the entire time you've been incarcerated? Okay.
Is it just the one medication though?
Yes.
When did you last take that?
This morning.
Okay. Does that medication in any way affect your ability to understand or appreciate where you are, what's going on around you, or anything like that? In a negative way? Does it hinder your ability to appreciate your surroundings?
When I'm not on it,
No.
I'm talking about when you're on it, when you take it.
no,
So it helps you if anything?
yes,
Okay. And you've been taking it like you're
Yes.
supposed to?
yes,
So that medication is not negatively affecting you right now in any way, is it?
no,
Okay. You know where you are, you've been able to communicate with your
Yes.
lawyer, you're understanding everything all right?
yes, I am.
Now, you would have received a copy of this indictment. It looks like you got it sometime back, maybe in the middle of December of last year. That's the document that sets forth the 9 charges you're accused of committing. Do you remember getting that?
Yes,
And at some point, did you have the chance to look that over?
yes, I did.
Now, in the indictment, as I said, you're charged with 9 counts. You're pleading guilty to 2 of those counts. I'm going to go over those 2 charges with you. And count 1 is one of those counts. And what's alleged here and what you'll be admitting to is on or about November 1st, 2025 in Lake County, Ohio, that you did in attempting or committing a theft offense or in fleeing immediately after you attempted or committed the offense, that you had a deadly weapon on or about your person or under your control, and you displayed the weapon, brandished the weapon, indicated you possessed the weapon, or used that weapon. That conduct constitutes the offense of aggravated robbery. It's a felony of the first degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes,
Any questions about that for me?
no,
Now, you're also pleading to the second firearm specification in this indictment, which alleges that you had a firearm on or about your person or under your control while you committed the offense, and you displayed the firearm, brandished the firearm, indicated you possessed the firearm or used the firearm to facilitate the offense, and that you further have previously been convicted of a firearm specification as described in 2941.141 of the revised code, that being in Cuyahoga County Common Pleas Court back on March 8th of 2016. Excuse me. You understand what's alleged with this firearm specification?
yes,
Any questions for me about that?
no,
In addition, in this count, there's what we call a repeat violent offender specification that alleges that you are a repeat violent offender, having previously been convicted of robbery, a felony of the second degree in the Cuyahoga County Common Pleas Court back on March 8th of 2016. You understand what's alleged there?
yes,
Any questions for me about that?
You have any questions?
no,
If you have any questions, just make sure you ask. The judge will give you time.
You have a question?
no,
You need a moment to talk to your lawyer at all?
no,
So you ready to continue on?
yes,
All right. Now, the next count you're pleading guilty to, or the other count you're pleading guilty to, is count 9. It charges you with having weapons while under disability. We'll get to that. And what's alleged here and what you'll be admitting to is on or about November 1st, 2025 in Lake County, Ohio, that you, not having been relieved from disability under operation of law or through legal process, that you knowingly had, carried, or used a firearm, and that you had previously been convicted of a felony offense of violence, that being robbery, a felony of the second degree in the Cuyahoga County Common Pleas Court back on March 8th of 2016. That conduct constitutes the offense of having weapons while under disability, a felony of the third degree. Do you understand what you're charged with and pleading guilty to in regards to count 9?
yes,
Any questions for me about that?
no,
Now, this charge also carries with it a couple firearm specifications. You're pleading to the first one, and that specification alleges that you had a firearm on or about your person under your control while you committed the offense, and you have previously been convicted of a firearm specification under 2941.141 of the revised code in the Cuyahoga County Common Pleas Court, again back on March 8th of 2016. Do you understand what's alleged in that specification?
yes,
Any questions for me about that?
no,
Now, there are 7 other counts of this indictment, and there's other specifications that we didn't review. Everything I didn't review with you is being dismissed pursuant to the agreement. Is that your understanding?
yes,
You have any questions about any of the other charges or specifications for me?
no,
You understand the nature of the charges and specifications that we did review and that you're pleading guilty to?
yes,
All right, well then, before I can accept your guilty plea to those, I need to make sure you understand all the rights you are giving up. And you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to all the evidence and I make that decision whether you're guilty or not guilty of each separate charge and specification. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be unanimous. Unanimous means all 12 of them would have to agree together, one way or the other, whether you're guilty or not guilty of the charges and specifications. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to have a trial in this case, in a jury trial?
Yes.
Now, if we did have a trial, you'd have the right to have an attorney represent you at that trial. If you could not afford an attorney, the court would appoint one for you free of charge to represent you at trial. Do you understand that?
Yes.
Now, at a trial, if we had a trial, the prosecutor here would represent the state of Ohio, and he would have what we refer to as the burden of proof. Having the burden of proof means that it's his job, or he bears the responsibility or the obligation. He bears the burden of proving you guilty at a trial before you can be found guilty. You're presumed innocent of all these charges and specifications, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when we speak of this burden of proof, since this is a criminal case, that burden is what we call proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges that I just read to you and the specifications beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges or specifications. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least to try to do that, if we're going to have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state, and they'd answer questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. He can ask them anything he wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court and testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes.
And you further can request the court issue an order. That order we call a subpoena. And what a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if there was anyone out there that wasn't willing to come in voluntarily on their own. Do you understand that?
Yes.
And do you realize you're giving up that right?
Yes.
Now, you also have a right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means is that nobody else could force you or make you. Nobody could compel you to have to get up on the stand and testify and answer questions if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, he wouldn't be allowed to call you as a witness and make you get up on the stand and answer questions. Testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
You further understand that if we went to trial and you were found guilty of any of these charges, you would have the right to appeal, or what that means is challenge that finding, that guilty finding, to another court, a higher court that sits above me and reviews my decisions. By pleading guilty today, you're giving up any right you have to appeal a guilty finding that I will enter if I accept your guilty plea, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right. Well, do you have any questions at all about all these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, I understand.
Do you still want to plead guilty?
Yes.
Do you understand a guilty plea is a complete admission of guilt? So that means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do this or that it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that guilty plea is that you will be found guilty by the court, and then you will subsequently be sentenced by the court on another day, not today, but on another date you'll be sentenced. You understand that?
Yes.
All right, now as far as sentencing goes, count 1 is aggravated robbery. It's a felony of the first degree that was committed on or after March of 2019, which means it's called a qualifying offense. And what that means is that any felonies of the first or second degree committed after that date are subject to indefinite sentencing. And when I say indefinite sentencing, what that means is that both a minimum sentence and a maximum sentence will be imposed for that count. Now, in this particular case, the court will determine what the minimum sentence is by selecting a number between 3 and 11. So I will select any number, 3, 4, 5, 6, 7, 8, 9, 10, or 11, and that would be the minimum sentence you would have to serve for count 1. You understand that?
Yes.
Now, the way the maximum sentence is determined, it's through a mathematical formula. You take half of whatever the minimum sentence is and add that half to the minimum sentence, and that becomes the maximum. So let me give you a couple examples. If I impose the minimum sentence of 3 years, half of 3 is 1.5. I'd add the 1.5 to the 3, so your maximum is 4.5 years. So the sentence would be 3 to 4.5 years. If I imposed 6 years as the minimum sentence, half of 6 is 3. You take that 3 and add it to the 6, that becomes 9. So your maximum sentence would be 9. So it would be an indefinite sentence of 6 to 9 years. You understand that?
Yes.
And I'm just giving you examples here. And if I give you the maximum, if I give you 11 years as the minimum sentence, half of 11 is 5.5. You add the 5.5 to the 11, that becomes 16.5. So the maximum sentence will be 16.5 years. So the maximum sentence on count 1 is 11 to 16.5 years. You understand that?
Yes.
Any questions about that?
No.
And again, those were just examples. It can be anywhere in that range of 3 to 11 as the minimum. And then the maximum is just by using that formula I talked about. You understand that?
Yes.
All right. Now, this count also carries with it a couple specifications. The first is a firearm specification. This particular firearm specification alleges you had a firearm on your person and you either used it, displayed it, brandished it, indicated you possessed it. And it also alleges that you previously had been convicted of a firearm specification. What the significance of that is that it requires the court to impose a mandatory prison term of 54 months, which is 4.5 years, which must be served prior to and consecutive to whatever sentence I give you on the aggravated robbery. You understand that?
Mm-hmm. Yes.
So you have to do this sentence first, whatever it is, and then you'd start serving the sentence on the robbery charge. You understand that?
Yes.
And there's going to be something different about that here in a second, I'll tell you. But that's an additional 4.5 years you'd serve prior to and consecutive with the sentence on the aggravated robbery. You understand that?
Yes.
Now, the charge also has with it what we call a repeat violent offender specification. This requires the court to impose an additional prison sentence if I give you the maximum sentence. So if I impose a term of 11 to 16.5 years, well, actually I don't have to do it. If I impose a term of 11 to 16.5 years, I then have the discretion to add an additional 1 to 10 years onto that sentence, which has to be served consecutive to whatever the sentence is. You understand that?
Yes.
Now, I'm not required to do that, and I can only do that if I give you 11 years as the minimum sentence on aggravated robbery. So if I give you anything other than 11, if I give you 10 years, 10 to, what would that be, 10 to 15 years on the robbery, I can't add any additional time on the repeat violent offender specification. I have to give you the maximum, and then if I give you the maximum, I can give you an additional 1 to 10 years, which would be a mandatory prison term that had to be served consecutive to the sentence. You understand that?
Yes.
When I use the term consecutive, I'm talking about one after the other. There's another term called concurrent, which means you serve the sentences at the same time. Consecutive is one after the other. These would have to be consecutive. You understand that?
Yes.
All right. Any questions about anything I just explained on this first count?
No.
Now, count 9, weapons under disability, charges a felony of the third degree. That carries with it a term in prison, a possible term in prison of 9, 12, 18, 24, 30, or 36 months. I'd select one of those numbers, and that would be the number of months you'd have to serve in prison for that count. Do you understand that?
Yes.
Now, this count also carries with it a firearm specification. This firearm specification requires the court to impose a mandatory prison term of 18 months that must be served prior to and consecutive to whatever prison term I give you on the weapons under disability, the 9 through 36 months. You understand that?
Yes.
And again, that's a mandatory prison term as well, the firearm specification. You understand that?
Yes.
So with this particular case, there's 2 firearm specifications that I'm required to impose. They have to be served consecutive to each other and consecutive to any other sentence I give you. So with the 2 firearm specifications, there's 6 years in prison that you will have to serve as a mandatory prison term before you begin serving whatever prison term I impose on the other counts. You understand that?
Yes.
So I need to be assured you understand the maximum sentence you face. I'm required to make sure you understand that. So if I were to impose a maximum sentence on everything I just explained to you, that would be an indefinite term of 11 to 16 and a half years on the aggravated robbery, and it'd be additional 4.5 years on the firearm specification, and it'd be an additional 10 years on the repeat violent offender specification for count 1. Count 9, the maximum will be 36 months or 3 years, preceded by another 18 months or a year and a half. If I imposed all those maximum sentences and ran them all consecutive to each other, the maximum sentence you face in this case is an indefinite prison term of a minimum of 30 years to a maximum of 35 and a half years. You understand that? Now again, that's the maximum. The minimum sentence you face in this case, if I were to give you the minimum sentence on everything, the minimum sentence would be an indefinite prison term of 9 years to a maximum of 10 and a half years. Do you understand that?
Yes.
So that's at a minimum, that's going to be the sentence. It can't be any lower than that. And it could be up to 30 to 35 and a half years. You understand that?
Yes.
Any questions at all about this?
No.
I know it's confusing, and I'm trying to make it set forth as simple as I can. You understand the specifications, that any prison terms imposed in the specifications have to be consecutive to each other and to any other sentence I impose. You understand that?
Yes.
And the aggravated robbery offense, I didn't mention this, but whatever sentence I impose, the 3, 4, 5, 6, 7, 8, 9, 10, 11, that's a mandatory prison term. The minimum is mandatory. You're not eligible for probation. You understand that?
Yes.
So the only prison term that of these terms that's not mandatory is the prison term that would be imposed in the weapons under disability. Everything else would be considered a mandatory prison term. You understand that?
Yes.
All right. Now, are you on probation or parole or PRC, any type of supervision to any other courts or agencies?
No.
Do you have any other charges pending against you anywhere?
No.
And before I go any further, is there anything else think we need to address with the penalties? I think I got that accurate.
I agree that it was what you delineated to the defendant is accurate, Your Honor. And Mr. Deeb and I have had numerous discussions about the pretrial discussions about this case. And I actually summarized the law, including the revised code sections, in the offer letter that I gave to Mr. Deeb that he reviewed with the defendant. So this is not the first time the defendant's hearing it. But thank you for asking. Yes, I agree.
Mr. Deeb, you satisfied as well?
Yes, Your Honor. I did go over the plea agreement with him when it was proposed, and we accepted.
But you're satisfied with my recitation of everything there?
You actually made it very clear. That's
All right.
probably the best recitation of Reagan Tokes I've heard.
All right, good. Thank you. All right. Let me explain a couple other things here in regards to that indefinite sentence. The way the sentences will work, as I mentioned, you're going to serve whatever sentence gets imposed on the specifications first. You would then serve the sentence on the weapons under disability. Once that's completed, if it's consecutive to the robbery, you'd have to serve it first. If it was concurrent, then you'd serve it at the same time. That's the only thing that could be concurrent. The weapons under disability and the aggravated robbery charge could be concurrent to each other. Everything else has to be consecutive. You understand that?
Yes.
Once you start serving the aggravated robbery sentence, which is the 3 to 11, it's the minimum with the maximum sentence, there is a presumption that you would be released after you've served that minimum sentence for the robbery charge. That means if I said the robbery, say, has 6 years, so it'd be 6 to 9 years. After you've served 6, and this would be, again, after you've served out any time for the specifications, there's a presumption that you would be released. Now, that presumption, it's just a presumption, which means it's not guaranteed. If the prison officials believe that while you were in prison, you committed violations of the rules, institutional infractions of the rules, that you remained a threat to the community, that you are not sufficiently rehabilitated, they can schedule a hearing. And at this hearing, they can present whatever evidence they have to that effect. And if it was determined that you did, in fact, commit rule violations or were still a threat, weren't rehabilitated, they don't have to release you after you serve the minimum sentence. They can keep you in. They would pick a new date for you to be released. And there'd be a presumption that you were released at that new time, unless, again, you continue to misbehave or were a threat, and they could do the same procedure and keep you in beyond that. However, under no circumstances can you be kept in beyond the maximum sentence. So even if you misbehave the whole time you're in there, they'd have to let you out after you serve the maximum sentence. You understand that?
Yes.
All right. Further, since these are mandatory prison terms that you are serving, you are not eligible to earn good time credit while you are in prison. You understand that?
Yes.
Now, upon your release from prison, you will be placed on post-release control in this case. Post-release control is sometimes referred to as parole or PRC. It's a period of supervision you would be on after you completed the prison sentence. And in this particular case, it would be for at least 2 years, and it could be up to 5 years. Do you understand that?
Yes.
You have that in here somewhere, I'm assuming?
Yeah, I was
Oh,
just
there it is,
looking
last
for that,
page,
Jeff.
page
It's on the
5.
last
okay.
page, yes.
Yep.
Okay. 2 to 5, yeah.
And if you are, or when you are on post-release control and you ever violate any of the conditions or rules of your supervision, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each separate violation you committed, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from the prison terms I've just mentioned to you, there's other sanctions that can be imposed. You could be fined. There's no mandatory fines, as we talked about at the beginning. The aggravated robbery charge carries with it a possible fine of up to $20,000. The weapons under disability charge carries with it a possible fine of $10,000 or up to $10,000. So altogether, there's a possible maximum fine of $30,000. Do you understand that? But
Yes.
no fines are mandatory. You understand that?
Yes.
You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes.
You could also be ordered to pay restitution to any victim for any economic loss any victim may have suffered for harm caused or damage caused as a result of your criminal conduct. Do you understand that?
Yes.
Also in regards, oh, never mind. Is there forfeiture specifications here?
There are no forfeiture specifications on the indictment. The defendant has agreed as part of the plea agreement that he's going to forfeit the firearm and all of the contraband that was seized incident to this investigation, Your Honor, that I've listed specifically at the bottom of page 3. Those are all the items that the police collected that are contraband that the defendant has agreed to forfeit.
You familiar with that property, Mr. Mason?
Yes.
Want me to review it with you, or did you go over that with him, Mr. Deeb? So at the bottom of page 3, there's a gun, magazines, ammunition, $8, some license plate, and some other items. You're going to be forfeiting all that at the time of sentencing. You understand that?
Yes.
And you agree to that?
Yes.
Okay. Now, a few moments ago, we went over all the penalties you face, and I told you that in this particular case, the prison is mandatory, which means I have to impose a prison sentence, which means you are not eligible for probation, what's called community control sanctions. You understand that?
Yes.
That won't be an option at sentencing. You understand that?
Yes.
Lastly, when we do go proceed to the sentencing hearing in about a month or so, you're going to have the right at that time to say anything you want, anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to follow that if I didn't think that was the I didn't think that was the right thing to do. Do you understand that?
Yes.
Okay. All right, well, do you have any questions at all about the potential penalties you face? What can happen at the time of sentencing?
No.
You understand all the possible consequences?
Yes, I do.
Do you still want to plead guilty?
Yes.
Have you had enough time to review all this with your lawyer, have him review the reports with you, discuss whatever issues there may be, answer whatever questions you have?
Yes, I did.
Are you satisfied with his advice and counsel?
Yes, I am.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here?
No.
Have you been threatened or coerced by anyone to plead guilty?
No.
Are you entering this guilty plea freely and voluntarily? This is what you want to do.
Yes.
All right, then. Do you have any questions for me at this point regarding anything we've talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to. Any questions at all?
No, no.
Do you need any more time to talk with your lawyer? If you did, I can give you some private time if you need to before the plea. Anytime?
No.
You're ready to plead guilty then?
Yes.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what he believes the evidence would show if we had a trial. I want you to listen to him and what he says, because then I'm going to have some questions for you about that, all right?
Okay.
Mr. D.
Thank you, Your Honor.
Mr. D, I'm sorry,
DePiero.
Mr. DePiero.
I thought you said Mr. D.
Started saying, I did say D, I apologize.
I mean,
Mr.
like
DePiero.
just the letter D, like DePiero.
Oh, no.
Anyway, this, Your Honor, the evidence would show November 1st, 2025, in Lake County, Ohio, that the defendant, Everett Mason, at about 2:43 in the morning was in the parking lot of the Green Ridge Hotel in a car. Now, at that time, he was in possession of a loaded, operable Glock pistol, which he was not supposed to have because he was under a disability by operation of his prior felony offensive violence and F2 robbery in Cuyahoga Common Pleas Court, March 8, 2016, case number CR15-602035A. Now, a couple minutes later, the defendant and an accomplice walk into the Green Ridge Hotel in Wickliffe, Lake County, Ohio. Both the defendant and the accomplice are wearing masks, dark clothing, and blue latex gloves. The defendant, they enter the building, the two accomplices. The accomplice is carrying a sledgehammer, full-size sledgehammer. The defendant approaches the glass front window, partition window, where the clerk sits, who deals with customers. There's no clerk there just yet. The accomplice walks over to the side. There's a side door that is attached to this office area where this clerk is going to come. So the clerk, he realizes somebody's there. He says, oh, we got a customer. And he walks into this office area where there's glass. The defendant has that pistol that I mentioned earlier. He has it in his hand. He's brandishing it, and he's pointing it at the clerk. The defendant then tells the clerk to open this side door for the accomplice who's carrying the sledgehammer, which the clerk does do that against his will. But he does it. So the accomplice with the sledgehammer walks into this office area. The defendant, then still brandishing the pistol, walks into the office area, and they order the clerk to get on the ground. And the defendant then goes through some drawers and a cash register, takes $174 in cash. That's all they could find right there, but they're not satisfied. There should be more. Now, there's an adjacent room to this room, Your Honor, right to the back. So the clerk is ordered on his feet. He's walked back to this adjacent room where the defendant and the co-defendant have the defendant go on the ground again, and they find there's what's called a drop safe, which is like a big safe, and you could just drop cash into the top of it. It kind of spins around, and then it secures the cash in there. So the co-defendant goes underneath this desk, takes the entire safe, and lifts it up and walks out of there. Okay, the defendant's still brandishing the weapon, takes the victim's phone, throws it in the bushes, and then they leave. Of course, they didn't have permission to have that safe, or the money that was in there, which is around $6,000. The defendant, that prior conviction that I mentioned earlier, Your Honor, that F2 robbery, the defendant also at that time pled guilty to and was convicted of a 1-year firearm specification under 2941.141. So that goes to this firearm specification here and the RVO spec on count 1. In a nutshell, that's what happened, Judge.
Thank you. Mr. Mason, were you able to hear what the prosecutor had to say regarding what he believes the evidence would show if we had a trial?
Yes.
And what, if anything, did he say about those facts as he presented them? Are those facts true? Did you do what he said?
Yes.
Very well then, regarding count 1, charging you with aggravated robbery, a felony of the first degree, what is your plea to that count?
Guilty.
Regarding the firearm specification, that you had a firearm on about your person or under control and you used it, brandished it, displayed it, indicated you possessed it, and you've previously been convicted of a firearm specification, what is your plea to that?
Guilty.
As for the repeat violent offender specification, what is your plea to that?
Guilty.
Any questions about that?
He's distraught, Your Honor. He's upset about what
Okay,
he's
all
done.
right, that's fine. I just, he
But
paused
yeah,
for a second, so I thought maybe
he
you had a
understands.
question. As the count 9, having weapons while under disability, a felony of the third degree, what is your plea to that count?
Guilty.
And as for the firearm specification, that you had a firearm on or about your person or under your control, and you've previously been convicted of a firearm specification, what is your plea to that?
Guilty.
All right, I have in my possession at this time, Mr. Mason, a document, it's 7 pages, which explains everything we've just discussed. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is that before I walked out here, you had a chance to review this with your lawyer, is that correct?
Yes.
Mr. Deeb, is that accurate? Can you
Yes, it is, Your Honor.
advise the court of measures you undertook in going over this with your client?
Your Honor, I went over it with them. The one thing that we didn't discuss was restitution. I believe that could be potential if they wanted for the safe that was taken. But I did go over the entire document with him. I answered all of his questions. He asked relevant questions, and I believe he understands that, and he has entered this plea knowing voluntary.
Is that correct, Mr. Mason? So you do understand the document?
Yes.
And your lawyer indicated he may not have reviewed restitution with you. Understand it's a possibility if there's a loss for the victims they may.
I did mention it to him, Your Honor, but in the guilty plea, you didn't mention restitution.
Yeah, I
don't
did.
believe. Oh, did you? I'm sorry.
No,
must have
I
missed
did.
it.
Pretty sure I did. You
I'm
don't
not
think
sure,
I did?
Judge. I'm not sure if he did.
You did.
Yeah, I did.
I know it was in the, that was
No.
the only thing. I'm
Okay.
sorry, Your Honor, if you did.
No, I
missed
mentioned it.
Okay.
But I made sure he was aware of that.
Okay. So you understand what the document says?
Yes,
Do you have
I
any
understand.
questions for me about it?
No.
It also appears that you signed it a couple times, once after the initial information was provided and at the very end with the sentencing chart. Remember signing it a couple times?
Yes.
You in fact did sign it?
Yes.
And you witnessed those signatures, Mr. Deeb?
Yes, I did, Your Honor.
And Mr. DePiero, you as well?
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect. The defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charges, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, aggravated robbery, a felony of the first degree in violation of 2911.01A1, as well as the firearm specification, the 54-month firearm specification set forth in 2941.145, and the repeat violent offender specification set forth in 2941.149. The court will further accept the defendant's plea and find the defendant guilty of count 9, having weapons while under disability, felony of the third degree in violation of 2923.13A2, with the 18-month firearm specification pursuant to 2941.141. All the remaining counts and specifications will be dismissed at sentencing. Sentencing, however, will be deferred. I'm going to order a pre-sentence report and investigation, a psychological evaluation, and the victim impact statements. And bond will be continued at $250,000 cash surety with the same conditions as previously ordered. I think that covers it. Mr. Shapiro, anything else that I omitted or need to discuss?
No, Your Honor. Thank you.
Mr. Deeb?
No, Your Honor.
All right, thank you.